Section 5. Right of religious freedom. No preference shall ever be given by law to any religious sect, society or denomination, nor to any particular creed, mode of worship or system of ecclesiastical polity, nor shall any person be compelled to attend any place of worship, to contribute to the erection or maintenance of any such place, or to the salary or support of any minister of religion, nor shall any man be compelled to send his child to any school to which he may be conscientiously opposed, and the civil rights, privileges, or capacities of no person shall be taken away, or in any wise diminished or enlarged, on account of his belief or disbelief of any religious tenet, dogma or teaching. No human authority shall, in any case whatever, control or interfere with the rights of conscience. Most of this provision formed a part of the first 3 Bills of Rights, and most of the original provision was borrowed from the Pennsylvania Constitution of 1790. The framers of the current Constitution added the clause, "Nor shall any man be compelled to send his child to any school to which he may be conscientiously opposed," in order that parents who wished to send their children to parochial or private schools could do so and would not be forced to send them to public schools should the General Assembly enact a compulsory education statute. The Kentucky Supreme Court has held that this clause does not prohibit the legislature from compelling attendance at any school, but this clause and Section 5 as a whole do prohibit the Commonwealth from certifying teachers in non-public schools and from prescribing what textbooks are to be used in such schools. The first part of Section 5 has been essentially the same in all 4 constitutions. In 1891, after the common school system was established in Kentucky, the provisions were included that state that no man can be forced to send his child to any school to which he may be conscientiously opposed and that guarantee the protection of civil rights from religious discrimination.
Section 6. Elections to be free and equal. All elections shall be free and equal. This section appeared in the 3 previous constitutions, and was apparently originally borrowed from the Pennsylvania Constitution of 1790, although one of the delegates to the Constitutional Convention of 1890 to 1891 traced its origins to the English Declaration of Rights of 1689. The delegates at that convention rejected attempts to delete the provision as a meaningless platitude, or to revise it to expressly prohibit voter intimidation and to guarantee that all votes should be given equal weight, which was said to be the true meaning of the provision.
Section 7. Right of trial by jury. The ancient mode of trial by jury shall be held sacred, and the right thereof remain inviolate, subject to such modifications as may be authorized by this Constitution. The framers of the Constitution of 1850 modified this section, which originally was taken from the Pennsylvania Constitution of 1790, by adding the language, subject to such modifications as may be authorized by this Constitution. The author of this edition introduced it in order to ensure that it would be constitutional for the legislature to grant the prosecution a certain number of peremptory challenges. Under common law, only the defense could peremptorily, or without cause, strike potential jurors from the panel. However, at the 1850 convention some advocates of law and order wanted the prosecution to have some peremptory challenges and hoped that a future legislature would so provide. Kentucky's first Code of Criminal Procedure, adopted in 1854, granted 5 peremptory challenges to the prosecution in felony cases and 20 to the defense. Currently, the prosecution has 5 challenges and the defense, 8.
Section 8. Freedom of speech and of the press. Printing presses shall be free to every person who undertakes to examine the proceedings of the General Assembly or any branch of government, and no law shall ever be made to restrain the right thereof. Every person may freely and fully speak, write and print on any subject, being responsible for the abuse of that liberty. The Pennsylvania Constitution of 1790 also served as the source of this section, which appears in all 4 constitutions, and was modified slightly in the most recent Constitutional Convention. The framers deleted the free communications of thoughts and opinions as one of the invaluable rights of man and changed citizen to person. While Pennsylvania had the most libertarian state constitutional provision on speech and press, the original meaning was much more restricted than in modern interpretations and probably was not intended to abolish the crime of seditious libel, which permitted the state to prosecute those who criticized the government in print or spoken word.
Section 9. Truth may be given in evidence in prosecution for publishing matters proper for public information, jury to try law and facts in libel prosecutions. In prosecutions for the publication of papers investigating the official conduct of officers or men in a public capacity, or where the matter published is proper for public information, the truth thereof may be given in evidence, and in all indictments for libel, the jury shall have the right to determine the law and the facts, under the direction of the court, as in other cases. In early American history, government could, and occasionally did, prosecute newspaper editors and publishers for the crime of seditious libel, which amounted to defaming or ridiculing the government, including its officers, and writing in a fashion that might undermine the public peace or public confidence in government leaders. Under English law, which theoretically applied in the colonies, the jury could only decide whether the defendant had published the allegedly libelous material and had to leave it to the judge to decide whether the material was libelous. The fact that a controversial statement was true did not constitute a defense, since the purposes of the law were to protect the security and reputation of the state and to punish public criticism of the government, no matter how truthful. However, in the seditious libel trial of Peter Zenger in 1735 in the colony of New York, the jury ignored the instructions of the judge and found the defendant not guilty, thereby creating a precedent for the proposition that the jury in such cases should decide whether the statement in question was libelous and could consider truth as a defense. Section 9, again appearing in all four constitutions and originally borrowed from the Pennsylvania Constitution of 1790, recognizes the crime of seditious libel, but does liberalize it by making truth a defense and allowing the jury to decide whether the printed material in question is libelous.
Section 10. Security from search and seizure, conditions of issuance of warrant. The people shall be secure in their persons, houses, papers and possessions from unreasonable search and seizure, and no warrant shall issue to search any place, or seize any person or thing, without describing them as nearly as may be, nor without probable cause supported by oath or affirmation. This section, which was taken from the Pennsylvania Constitution of 1790 and resembles the Fourth Amendment to the federal Constitution, has appeared in all four Kentucky constitutions with essentially the same language. A basic historical foundation of these provisions stemmed from colonial opposition to the British writ of assistance, a general search warrant that authorized imperial officials to conduct open-ended searches of individuals suspected of smuggling and other crimes.
Section 11. Rights of accused in criminal prosecution, change of venue. In all criminal prosecutions, the accused has the right to be heard by himself and counsel, to demand the nature and cause of the accusation against him, to meet the witnesses face to face, and to have compulsory process for obtaining witnesses in his favor. He cannot be compelled to give evidence against himself, nor can he be deprived of his life, liberty or property, unless by the judgment of his peers or the law of the land, and in prosecutions by indictment or information, he shall have a speedy public trial by an impartial jury of the vicinage, but the General Assembly may provide by a general law for a change of venue in such prosecutions for both the defendant and the Commonwealth, the change to be made to the most convenient county in which a fair trial can be obtained. This section, with some modification, appeared in Kentucky's previous constitutions and has as its original source the Pennsylvania Constitution of 1790, whose exact language was incorporated into the first constitution. That language also was used in the second and third constitutions, although the framers of the latter provided in a separate section that the General Assembly could no longer change the venue in criminal cases and rather should provide for such changes by general laws. The framers of the current Constitution added the venue clause to this section and expressly provided that the General Assembly could by general law change the venue for the Commonwealth as well as the defendant in the belief that prosecution-directed venue changes were needed to combat lawlessness in certain feud-ridden counties.
Section 12. Indictable offense not to be prosecuted by information exceptions. No person, for an indictable offense, shall be proceeded against criminally by information, except in cases arising in the land or naval forces, or in the militia, when in actual service, in time of war or public danger, or by leave of court for oppression or misdemeanor in office. This provision, which was taken from the Pennsylvania Constitution of 1790, effectively requires that those whom the Commonwealth wishes to formally accuse of serious crimes, except mostly those committed when in wartime military service, must be charged by grand jury indictment. An information is a charge brought by a prosecutor alone, without grand jury involvement. In Kentucky, a grand jury consists of 12 citizens selected at random from the pool of individuals summoned to jury service at the beginning of each term of the local trial court, the circuit court. A concept adopted from the English system of criminal justice, the grand jury determines whether there is probable cause to charge or indict someone with the commission of a serious crime, usually termed a felony. Military crimes are accepted because they are traditionally tried by military courts. The grand jury offers individuals suspected of crimes an additional protection in that it may choose not to indict someone whom a prosecutor wishes to indict. Critics of the grand jury argue that this protection is limited since only the prosecutor presents evidence to the grand jury, which consequently usually does what the prosecutor wishes.
Section 13. Double jeopardy, property not to be taken for public use without compensation. No person shall, for the same offense, be twice put in jeopardy of his life or limb, nor shall any man's property be taken or applied to public use without the consent of his representatives, and without just compensation being previously made to him. Being very much the same as the relevant provision in the Pennsylvania Constitution of 1790 and with the same language as its predecessors, this section has objectives similar to the double jeopardy and taking provisions found in the Fifth Amendment of the Federal Constitution. In the language of one of the earliest interpretations of this section, the objective of the double jeopardy provision is to ensure that no one can be twice punished for the same crime or misdemeanor. The framers of the current Constitution rejected efforts by Law and Order advocates to weaken the double jeopardy clause of this section.
Section 14. Right of judicial remedy for injury, speedy trial. All courts shall be open and every person for an injury done him in his lands, goods, person or reputation, shall have remedy by due course of law, and right and justice administered without sale, denial or delay. This section provides for another basic principle of Anglo-American law, namely that the courts shall always be accessible for the prompt redress of grievances. The language is that of a similar provision in the Pennsylvania Constitution of 1790, although the framers of the first Constitution omitted a final sentence concerning suits against the Commonwealth and placed a variation of that declaration in a different article of the Charter. The federal Constitution contains no such express guarantee of access, although it is implied in various amendments including the 1st, 5th, and 14th Amendments.
Section 15. Laws to be suspended only by General Assembly. No power to suspend laws shall be exercised unless by the General Assembly or its authority. Taken from the Pennsylvania Constitution of 1790 and little changed over the course of 4 constitutions, this provision originally reflected the desire of the framers of the earliest state constitutions to prevent the suspension of laws, a power reserved to the British government over certain statutes enacted during the colonial period of American history. Thank you for viewing this history of the Kentucky Constitution. For more information, please see the following references. Citizen's Guide to the Kentucky Constitution by the Legislative Research Commission, available online. Or the book, The Kentucky State Constitution, by Robert M. Ireland, Oxford University Press.